Good morning, everyone. We are definitely excited to bring you this presentation about the new family caregiver leave benefit that New York State has brought to its citizens. This presentation is brought to you by PSS Circle of Care and Jackson Lewis PC. PSS Circle of Care provides free, confidential, professional support to family caregivers caring for a frail or chronically ill family member or someone with Alzheimer's disease or other dementias. Our wonderful care consultants will work with the family caregivers to really give them support. We provide information and referrals, help with vital benefits and entitlements. We run support groups in person, on the phone, online, different training and online resources. For example, this wonderful webinar, temporary respite for caregivers, health supplies, transportation, and we do have services in English and Spanish at this time. And we have our hotline here, so if you need to call in for services, please do so. As I mentioned, we partnered with Jackson Lewis PC to bring this wonderful presentation, and we have two great attorneys with us today. Benjamin Yemens is an associate with the White Plains, New York office of Jackson Lewis PC. His practice focuses on representing employers in workplace law matters, including preventative advice and counsel. Prior to joining Jackson Lewis, Mr. Yemens was an attorney in the Labor Relations Department of Coca-Cola Refreshments, Inc., where he handled a wide range of traditional labor and employment matters. As a member of the firm's disability leave and health management practice group, Mr. Yemens spends much of his time counseling employers on complex leave-related and disability issues. Joseph De Palma is an associate with the White Plains, New York office of Jackson Lewis PC. He represents employers of varying sizes and industries in a wide range of labor and employment matters, including collective bargaining, union grievances, employment litigation, and traditional labor practices. Mr. De Palma is a member of the firm's disability leave and health management practice group. He focuses a large part of his practice on counseling employers by providing creative solutions to complex array of workplace disabilities and health management issues faced by both large and small employers. Mr. De Palma counsels clients with the goal of either avoiding litigation and entirely or improving outcomes before administrative agencies, courts, and juries. Mr. De Palma also counsels clients concerning public accommodation issues with significant experience defending employees in ADA Title III litigation. So these two guys know a lot. So we're very happy to bring them here. And if you do have any questions, please write them in the chat. As at this point, Joe and Benjamin, I will turn it over to you.
Okay, thank you very much. We're happy to be here. Joe and I this is a very hot topic nowadays, the New York Paid Family Leave Law, which I'm sure many of you heard about. So we're pretty excited to speak about this topic to your group. And I'm going to kick it over to Joe to take us off here.
Good morning, everyone. So today, the goal for the program is really just to cover the PFL basics. So when you hear us say PFL, we're talking about New York Paid Family Leave, which is the new law that came into effect on January 1st, 2018. We're going to try to give this to you with an eye towards what we've learned so far. A lot of what we were doing on this last year was just predicting what would happen when 2018 rolled around. So now that our clients are mostly businesses who are dealing with this from the other end and how to administer this benefit for its employees, but the issues that they're getting from their employees and how to handle it going forward. So you can go to the next slide. So just some basics. This law was originally signed in April of 2016, and it took some time from April 2016 up until January 1st, 2018 for it to become effective. One of the main reasons why it took so long is the New York State government had to come up with regulations on how this law should be carried out in practice. So we have regulations. Those were finalized in July of 2017. The state has also issued forms that are required to be used at least the template of the forms that are required to be used to administer this benefit. This law is very expansive in that it covers basically all private sector employers. It doesn't cover public employers automatically. They can opt in by filing an application. So if you work for a private employer, there is a very good chance that this law applies to such employer. The law, the way it was created, which helped it achieve so much support, is that it's not costing companies, or it's not supposed to cost companies anything to have the benefit. Rather, the way that it's being done is through payroll deductions. So the employer has the ability to charge its employees payroll deductions at an amount of 0.126%, which we'll get into a little bit later, of an employee's average weekly wage, subject to a maximum. But all of those monies that are funded through payroll are then paid to an insurance carrier or to the employer to be able to fund this benefit. And as we go through the slides, this will make a lot more sense. And those of you who are aware of New York State disability benefits, this law is modeled in large part after that. So the systems that are in place for disability law are very similar to the paid family leave.
Okay. So, what we like to call this is, the 3 Ps here, that what makes paid family leave so important. The first is that this is a paid leave benefit, right? Many of you may be familiar with family medical leave, or FMLA, which is unpaid, right? So that sometimes inhibits people from taking leave because they're not going to receive any pay. Whereas the pay under paid family leave, or PFL as we'll call it, is pretty significant, in that it's up to 50% of an employee's wages at a certain cap. It's much more generous than the New York disability, short-term disability benefits, which has, currently has a cap at about $170 per week. So paid family leave is significantly more than that. Paid family leave provides job protection. So that's another big difference between paid family leave and New York disability, right? When you go out on short-term disability, you don't have any job protection. Whereas if you go out on PFL, you receive job protection. And we'll touch on that later, but that essentially means that you have the right to be reinstated to your job or to an equivalent job with equivalent pay and benefits. Employees and employers who are not covered by FMLA are going to be covered by this law. So, while this is going to create some absence management challenge for employers, it also gives employees opportunities to, use necessary paid leave to care for a family member or to bond with a child in situations where they otherwise wouldn't have been allowed to use leave, because and we'll touch on this in a little bit, but employers are only subject to the FMLA if they have 50 or more employees, whereas PFL covers virtually every private employer, regardless of the size of the employer. And then there's a new process to administer for PFL requests, right? PFL is administered by insurers or an internal company who's self-insuring the benefit themselves, and that's where the challenges are to integrate the administration with those managing FMLA and PTO and any parental bonding policies that they may have.
Okay, so one of the first questions that need to be asked are which employees are entitled to receive paid family leave. So the law thinks of employees basically in 2 different ways: those who work 20 or more hours per week and those who work less than 20 hours per week. So from an initial eligibility standpoint, if you're an employee who works 20 or more hours per week on average, after 26 weeks of employment, you would be eligible for paid family leave benefits. If you're an employee who works less than 20 hours per week, you'd be eligible after you work 175 days. There isn't any time frame in which you need to work 175 days. So if it takes an employee 3 years to work 175 days, that would be sufficient to meet initial eligibility standards. And this is important to make the determination as to if an employee presents a reason why they want to take paid family leave. The first threshold that needs to be met is this employee eligible? And this is how employers make that determination. Did they work enough, essentially? There is an ability for certain employees to opt out of paid family leave. And the reason an employee would want to do that is so no payroll contributions are withheld from their pay. So to be eligible for the waiver, the employee needs to have a regular employment schedule of 20 more hours per week, but it's known that the employee will not work 26 consecutive weeks. And where we see that most often are temporary employees or seasonal employees who just come on for the summer. And when they're hired, the employer and the employee both know that they won't work the 26 weeks. In that scenario, the employer has to give the employee the option to file the waiver, meaning that no deductions will be held from that employee's pay. The other way that an employee can qualify for a waiver is if they work less than 20 hours per week, but it's known that they will not work 175 days in a 52-week period. So whereas the 175 days that I mentioned before for initial eligibility doesn't need to be done in a certain amount of time, that needs to be distinguished from this waiver scenario where you look to see if the employee's regular work schedule is such that they will work 175 days in a 52-week period. And if the answer to that is no, then they need to receive the waiver. The waiver is completely optional for employees, so just because they're provided with the waiver doesn't mean that he or she needs to sign it. It just gives them the ability to do so.
Okay, so now there are three general reasons for the leave. The first is care for a family member. So when paid leave is necessary to provide care, and that includes both physical or psychological care to a family member due to the family member's serious health condition. So that's one reason of how an employee who's eligible for PFL can take the leave. They can take the leave to care for the family member. They can also take the leave to bond with a child. And this is during the first year of the child's life, or in the case of adoption or foster care placement, for the first year after the placement of the child with the employee. And then lastly, for a military qualifying event, which is basically the same reason as provided for under the FMLA, which arises from the employee's spouse, domestic partner, or child or parent being on active military duty, or alternatively being notified of an impending call or order to active military duty. So you notice the major difference between PFL and FMLA, which many of you may be familiar with, is FMLA includes the care, for one's own health condition. So if an employee has a serious health condition themselves, they're eligible to go out under FMLA. Something like that is not covered by PFL. So PFL only covers the care for someone else, the health condition of a serious family member, to bond with the child, or for a military qualifying event.
Okay, so just quick little recap. The first thing you make the determination, is the employee eligible, i.e. did they work enough? 2, did they present a qualifying reason for leave? And then the third thing now we're up to is how much time off and pay is the employee entitled to? PFL phases in over the course of 4 years. So right now, January 1st, 2018, employees are entitled to 8 weeks of pay at 50% of the employee's average weekly wage or 50% of the statewide average weekly wage, whichever is less. Now that phases in to 10 weeks at 55% in 2019, 10 weeks at 60% in 2020, and then when it fully phases in 2021, it will be 12 weeks at 67%. Now the employee's average weekly wage is a calculation that basically does a look back for a period of time to see how much money the employee earns on average over that period. The statewide average weekly wage this year in New York is $1,305.92. So the calculation is done. If the employee, let's say hypothetically, makes $2,000 a week, 50% of their average weekly wage is $1,000. 50% of the statewide average weekly wage is 50% of $1,305.92. You would see whichever of those two are less. In this case, it would be the state average weekly wage, and that's the amount of money the employee would be entitled to for each week of their paid family leave in that year.
So just to piggyback on what Joe was saying, for 2018, because the statewide average weekly wage is $1,305.92, and employees receive 50% of that, the maximum an employee can receive in 2018 is approximately $653 per week. So if you make less than the $1,305.92, you're going to make 50% of whatever you've earned. If you make more than the $1,305.92 per week, you're going to be maxed out at about $653 for 2018. And as we touched on before, employees are entitled to job protection under paid family leave. So what this means on a very basic level is that the employee is entitled to be restored to the position of employment they had when the leave began, or to a comparable position with comparable employment benefits. Now, sometimes when employees go out, it's possible that the exact position that they had would no longer be available. This is especially the case where an employee may go out for an extended period of time, right? So if an employee goes out on PFL for the full 8 weeks, their precise position may not be available. However, the employer is responsible and is required to put them in a comparable position with comparable employment benefits, pay, and other terms and conditions of employment. Now, obviously, since this is a new law, there's been no case law or judicial guidance offering any perspective on what it means to be a comparable position. However, if we look at some of the cases where under FMLA, where there's many cases under FMLA of employees challenging that they weren't restored to a comparable position, the courts have made it pretty clear that it really does need to be a comparable position in almost every way. You know, there have been cases where even minor changes in an employee's schedule would not be considered comparable. So that's just something to keep in mind. If somebody goes out on this leave, they are entitled to be restored to a very comparable position, if not the same position.
And in addition, while employees are out on paid family leave, they're, in addition to job protection that Ben just explained, they're also entitled to certain other things. So one of which is that they're entitled to stay on the same health insurance plan with the same coverage as the time that they were working before the leave. So this means if an employee was receiving Cigna health insurance and they were paying 10% of the premium, that would continue throughout the duration of the leave. So that means the employer would still be able to collect whatever the employee owes for health insurance, even though the employer may not be paying the employee because the employee is receiving money from the insurance carrier through the PFL benefit. Taking PFL also cannot result in the loss of any employment benefit accrued prior to the date on which the leave commenced. So if you as an employee are entitled to a certain benefit, maybe a bonus that accrued prior to the taking of the leave, that benefit will still be there even though you took paid family leave. The employee is not entitled, however, to the accrual of any seniority or employment benefits during PFL. So if the employer has a practice that you need to be working to continue to accrue vacation days, for example, while you're on PFL, it's permissible for the employer to not continue the accrual of those vacation days. And then the last point there just says that the employee isn't entitled to any right or benefit that he or she would have been entitled to had she not taken a leave. So for example, if the company was doing a mass layoff and getting rid of an entire department, and you were in that department that they were laying off due to economic, legitimate business reasons, just because you're on paid family leave doesn't mean the employer still can't move forward with the termination of employment on that basis.
Okay, so with respect to disputes and penalties arising out of PFL, if an insurer or a self-insured employer denies the claim for PFL, they are going to issue you a form, which is essentially a denial letter issued to the employee stating that PFL has been denied, and it'll provide the reason as to why PFL has been denied. So now any claim-related dispute, which involves eligibility, benefit rate, and the amount of leave that's taken, is subject to arbitration at the Workers' Compensation Board, and the carrier or the self-insured employer is responsible for fees. So what that means, if an employee thinks they should be eligible for PFL, but the insurance carrier determined that they're not eligible, and the employee believes that the employee is correct in that matter, they can file a claim for arbitration with the Workers' Comp Board. If they feel that they're getting paid less than they should be under PFL benefits, they can also file a claim. Those are the types of claims that are going to go to arbitration. Now, a claim that will not go to workers' comp arbitration is an employee who believes that she or he has been discriminated or retaliated against for taking PFL. So this may come in the form of an example of an employee who goes out on PFL and then they come back and the employer does not restore them to a comparable position, right? Let's say the employer restores them to a less favorable position with less favorable pay. So that employee may feel that they were discriminated or retaliated against for taking PFL. In such a case, the employee is entitled to file a claim under Section 120 of the Workers' Compensation Law. And that's the same process that's in place right now if somebody feels they were discriminated or retaliated against for going on short-term disability. Now, there's significant penalties for failing to provide coverage and health insurance continuation during PFL leave. So if you don't have coverage at all, an employer doesn't have any coverage at all, they can be subject to fines of up to 5% of weekly payroll for the period without coverage. The employer will be responsible for full wage replacement benefits. And now if the employer also cancels the employee's health insurance unwarranted under PFL, the employer could be responsible for all of the employee's medical costs. So that's just something that you should keep in mind as employers are administering PFL and as employees are taking PFL.
So one of the most common questions that we've been receiving from our clients is how to calculate the benefit. What is an employee entitled to? So we said before that the employee is entitled to 50% of their salary or 50% of the average weekly wage, whichever is less. So the PFL-1 form, which is one of the forms that are going to be required to fill out by any employer and employee when an employee requests leave, has a section on it for the employer to put out what the employee made over the past 8 weeks. So you look at each different week to see what the employee earned. Now this amount would include any overtime worked that week. It would include a prorated bonus to the extent that the employee receives a bonus, and that's the number that will ultimately come out and be submitted to the insurance carrier saying this is what the employee makes that week. The insurance carrier then will take that information, compare it to the statewide average weekly wage, and make a determination that this is what it believes the employee is entitled to, based upon the information that it was provided from the employer and the employee. So it's the insurance carrier and not your employer who's ultimately making the determination as to what the benefit is. Like Ben said before, the cap, the most an employee, no matter how much money they make in 2018, the most that they can receive as a PFL benefit is 50% of the statewide average weekly wage, which is about $650. So this is a fairly lucrative benefit in comparison to anything else that ever existed. FMLA, those of you who are familiar with that, that's an unpaid leave. Short-term disability in New York, which this is largely modeled after, has a maximum weekly earning of $170. So 650 in comparison to 170 is fairly significant. So we anticipate seeing a larger number of employees in the state taking these types of family leaves that maybe they could have taken under FMLA but didn't due to the unpaid nature of that leave. They will potentially take it now.
So one of the questions is can you run paid PTO policies and paid time off policies with PFL, right? So as you may know, FMLA generally can run concurrently with any voluntary company leave policy, whether paid or unpaid. So for example, if an employee goes out on FMLA, the company may require the employee to exhaust vacation or other PTO at the same time. The employer has the ability to do that. It's not as clear under paid family leave, right? Because it lumps accrued paid time together with other types of paid family leave. And if you jump down to the last bullet here, what's most significantly different between PFL and FMLA is that under PFL, employers cannot force employees to use PTO, right? They have the option to, but you cannot force an employee to. So there's nothing preventing an employee from using his or her full PFL allotment, let's say in 2018 is 8 weeks, without having burned any vacation or any other PTO. They do have that ability. So the next topic we want to touch on is integrating with PFL and FMLA and existing benefits and policies. This is a little bit more of a complex topic, but we'll try and move through it, at least covering the most basic and simple points so that you all have an idea of how this generally works.
Okay. So New York Paid Family Leave and the Federal Family Medical and Leave Act are very similar in a lot of ways. So this chart is just a general overview of how they're different. So those of you out there who are employees who may have used FMLA before, this is a good guide for you to determine how PFL is similar to that, how it's different than that, etc. So one of the big differences is that FMLA only applies to the 50 or more companies with 50 or more employees in a 75-mile radius, whereas PFL does not have that restriction. In addition, the eligibility requirements for FMLA are a little bit more onerous. So if you're an employee of an FMLA covered employer, you need to work for 12 months and 1,250 hours prior to taking FMLA, whereas PFL is less restrictive. It's 26 weeks if you're a full-time employee. PFL also includes some additional family members that FMLA does not. So if you're seeking leave to care for a family member with a serious health condition, and that person, let's say, is a grandparent, grandchild, domestic partner, parent-in-law is also included. You may be eligible for PFL, but you wouldn't be eligible for FMLA in those scenarios because those aren't covered family members under the FMLA. The other huge difference is that, like Ben said before, FMLA applies to employees' own serious health condition, whereas PFL does not. So if an employee presents a need that they need to take leave because of their own medical condition, that would be an FMLA scenario potentially, but it wouldn't be a PFL scenario.
So there are specific notice requirements in order to run PFL and FMLA concurrently, right? So if an employer wants to run them concurrently, and this is something that employees should make note of, is that employers must give notice to employees that PFL will run concurrently with FMLA. If an employer fails to provide the notice, the employer is not going to be able to run PFL concurrently with FMLA, and this results in quote-unquote stacking of PFL leave, which means that an employee would theoretically be able to take all the FMLA entitlement, which would be 12 weeks, followed by PFL, which would be 8 weeks. So you have to provide the notice that supporting documentation and certifications are required. So similar to like FMLA, federal FMLA. And now, and the one unique aspect is when the total hours taken for FMLA in less than full day increments reaches the number of hours in an employee's usual workday, the employer may deduct 1 day of PFL benefits from an employee's available annual PFL benefits. So what this means is that under PFL, employees cannot take PFL in less than full day increments, right? As an employee, you cannot call into your employer and say, I'm taking PFL for 4 hours of an 8-hour day. You can call in PFL for a full day, that's the minimum increment, but you can't call in less than that. Whereas FMLA, you do have the ability to call in for hours at a time. So to the extent that an employee is using FMLA in less than full day increments, once that employee reaches their full regular day, let's say an 8-hour day, the employer has the ability to dock 1 day of PFL. So as for an example, if an employee has a regular workday of 8 hours a day, and on Monday and Tuesday, the employee calls in FMLA for 4 hours on Monday and for 4 hours on Tuesday, once they've hit 8 hours, the employer has the ability to dock 1 day of PFL. Okay, so that's sort of one of the more fundamental issues and points of analysis that it's very important for employees and employers to know as they determine how much leave they have available and how they're going to use this leave. You know, us at Jackson Lewis, we have, as this is a new law and this is a very significant law, we've developed teams of our attorneys in our 4 New York offices to handle these types of questions. So, you know, certainly don't hesitate to contact anyone from any of our offices to deal with these questions. With that, that's the end of the presentation. We want to thank everyone for tuning in, and we'll turn it over back to Circle of Care.
So, Ben and Joe, I just have a couple of questions. This is Kimberly, so I just want to make sure that we're clear on it. One, the waiving. So, a full-time employee, and they feel like they're never going to use this. Can I waive it?
So the initial inquiry there is when you say full-time employee, that I'm assuming they work 20 or more hours per week. If the employee wants to waive it.
So a regular, 5-day-a-week, 8-hour-a-day employee that would fall in any of these categories, can I just say, I don't think I'll ever need this. I don't want you taking the money from me.
No. The only way that they're entitled to the waiver is if they're not going to work for the 26 consecutive weeks. And that could be measured at the time they're hired. So like I said before, if it's a seasonal employee or a temporary employee where you know they're only going to work 12 weeks or something along those lines, then they can opt out. But if the idea is that they're going to be an at-will employee and be employed there for years and years and years, there's no ability to waive.
So the other question is, in the situation where we are not your employer allows you to use FMLA and then use the paid family leave, so not running concurrently, how much leave time in a year with all the different sort of leaves out there can I use in a year?
Well, if the employer doesn't designate the PFL leave to the FMLA leave, or say if there's different reasons, FMLA for your own serious health condition and then PFL, in 2018, you have a 12-week entitlement to FMLA, then an 8-week entitlement to PFL. So that could be 20 weeks.
So in a given 12-month period, depending or whatever the year, 20 weeks of leave time might be the maximum.
It wouldn't be paid. It would be the 12 weeks FMLA would be unpaid.
Right.
And you'd have to go to employer-specific policy. Right. And then week PFL.
Right. But that's basically 20 weeks of job-protected leave.
Right, and there are other caps. For example, an employee cannot exceed 26 weeks between disability and PFL. So to the extent that an employee, let's say in 2018, uses 20 weeks of disability, they would only be entitled to 6 weeks of PFL in that same period.
Gotcha. Thank you, gentlemen. Are there any particular other questions, anybody in the chat room? Okay, so I definitely want to thank you again. This was very informative. Definitely tell your friends about the paid family leave so they can check at work with their employers. Joe and Ben, thank you very much, and we appreciate your time.
Sure.
No problem.
Okay, thank you. Have a good day.
Enjoy your day.